Okay, guys, welcome back to another Lawyered Up. I know normally on Lawyered Up I'm kind of in a low mood because I'm like, it's difficult, the political system that we operate in. But today there's some interesting stuff that's happened, and I think it's good news. Now, on the middle of the road news to start off with, if you looked at the description of this video, you may have seen that AG Wisner was not confirmed. And TY Pro, I see your question in there asking about counselors who opposed her explaining their votes. One of the things I'm going to mention here too is, I think it was the BF&J committee meeting right before the most recent council meeting where AG Wisner was not confirmed. They interviewed AG Wisner, I think it was BF&J. And it was a pretty long interview, and they asked a bunch of questions. And it's on the National Council's YouTube channel right now if you want to go check it out. AG Wisner also raised some cases that she was looking into, some of them being some allegations that in Mvskoke citizens were being held without being charged and some other things. And then also a civil case she mentioned in Eufaula. I sent her an email to try to find out if she could send me some more information so I could look those cases up and find out what they're about, because they were listed in things that she is going to be trying to address in the coming months or so. So that's also from that interview that she had with the council. But just as far as the councilmen explaining their votes, I think what we're seeing here is, and from my experience, I received a lot of calls and talked to a lot of citizens who were unhappy with AG Wisner's performance, specifically in the Kennedy case, but also some other cases. And that's why that question started to pop up when we did the candidate interview videos about, are you going to confirm AG Wisner? And some of those candidates who said that they were going to vote no on her and not confirm her, they got elected. So you would expect them to do what they told citizens they were going to do, which is vote no on her. Now, what is the status of the AG's office right now? Because I think there is some confusion there, but I want to clear it up. So let me pop up on the screen our laptop here. So I'm on the Creek Supreme Court's website, and I'm looking at the Constitution. We're going to go down to Article 5, Section 2. And so we see here it says, C says, the principal chief shall have the power to fill vacancies by granting commissions which shall expire at the beginning of the next, hold on, let me highlight that. Next council meeting. So, and that is what Chief has done. He issued an email saying that he's commissioning Ms. Wisner as the AG until that next council meeting. So she is the official AG still, even though she hasn't been confirmed. And I imagine we would probably see a continuing commission until, if they find someone else to submit, we'll really see at the next council meeting if Chief Hill is going to continue to submit Ms. Wisner to try to get her confirmed, or if he's going to try to put somebody else in there. We'll just have to watch and see. While we're on the Supreme Court's website, I wanted to also show you guys something very interesting here. We have a new link at the top of their page. It says current docket. Now, you guys may have remembered me complaining about trying to get documents out of the Supreme Court. If you remember back in I think it was the Kennedy case, there was a stay issued by the Supreme Court that I could not get from the Supreme Court, and I ultimately got it from the Attorney General's office. And at this last council meeting, I believe there were a couple of Supreme Court justices that were reconfirmed. So this is great. We see the current docket. We see the dockets, and then if you click them, right, you can go in and read the filings in this case. One of the links, let me pop me back up here real quick. One of the links that's in the description down here is a letter that I received from Justice LeBlanc in 2021, and it's a denial of records. I was requesting the filings for the, let me pop it up real quick while that's loading. Here it is. The filings for the Supreme Court case, whoops, whoa. Sorry, guys. First day with a laptop. Let me zoom that out. Okay, here we go. That's really zoomed in. I was requesting the filings in Adam Jones and Lanissa Melton's petition for fraud and irregularities in the 2021 primary. I don't know if you guys remember back then, but there was a case filed where they were challenging the results of the election, and it went to the Supreme Court, and I was trying to get the filings that they had made, and I received this where, and this, let me zoom out one more time. You can see there at the bottom, Richard LeBlanc, Chief Justice, is telling me that they are not going to give out any records until the case is quote-unquote completed, and then they will release it. So we're seeing a big change here from then to now, where you can go and actually look at the filings in the case. There hasn't been a decision in the Kennedy case yet, but we can look at the filings in the case and these other cases too. Let's go back. So you guys go and check that out. It's pretty interesting. It is a new development, and I applaud the Supreme Court because this is really going to throw a lot of light on their process. When there is a case in the Supreme Court now, we will be able to go and read what's been filed, if there's a stay been filed, and so on and so forth. Let me see. Let me check my list here and see where we're at. We've gone through there. Okay, so we are at the meat and potatoes for this episode. We're going to be talking about a writ of habeas corpus that Oklahoma State AG Gettner Drummond filed in relation to the incident that happened at the Okmulgee County Jail that has everybody's covered and everything. So, and just in a nutshell, what happened, some light horse tried to drop a prisoner off at the Okmulgee County Jail. The Okmulgee County Jail guys, Matthew Douglas and I think, I can't remember the first name, but Shannon, I think, is the guy who runs the jail. We're going to read some about it in a second. But basically what happened is they wouldn't accept the prisoner, and then at a certain point, I believe it is somebody goes through an access door while it's closing that they shouldn't have, and it resulted in a physical altercation. And that resulted in the AG's office filing a charge of assaulting a tribal police officer against one of the jail employees, Matthew Joseph Douglas. Okay, and that case is set for, I believe, arraignment on March 27th. So before that arraignment happens, Gettner Drummond has filed this writ of habeas corpus to, and we'll just pop this up real quick because I happen to have it out. In the U.S. system, let me pop this up for you guys. The federal courts can use a writ of habeas corpus to determine if a state's detention of a prisoner is valid. Now, just to clarify, I'm going to click over here and go into this so that you guys can see. Matthew Joseph Douglas is not being detained physically right now by the Creek Nation, and it's addressed in this filing, but when he was released on, let me look at for the wordage here. He was, this part here delineates how it says, for reasons set forth in Section 4A below, petitioner is quote-unquote detained and is not required to litigate this issue in a tribal court that lacks jurisdiction over him. So he's saying that even though he was released, he's not being held in jail or anything, because he was, his arraignment hasn't happened yet, he's still technically detained. Okay? Now, the thing that I want to show before we get into the politics of this, or like kind of the painting of this, what I wanted to talk to you guys about first was So what's going on here? What's actually happened beyond there was a disagreement? And that's why I also wanted to bring what we're going to look at right now is the state of Oklahoma. It's Drummond's filing. It's not a Creek Nation filing. We didn't file this. And so part of this filing is he's going to give what the state of Oklahoma believes is what happened, right? And I wanted to point out to you guys some things here. So let me pop this back up again. Events of December 18th, 2023, 3 MCN Light Horse officers brought an arrestee to the jail on December 18th. One of those officers filled out an arrest and booking data form that reflected the arrestee was being accused of violating Oklahoma law by possessing a controlled dangerous substance within 1,000 feet of a school. Then we're going to skip ahead here. And then it says, as depicted in body-worn camera video downloadable from MCN press release, an altercation occurred between members of MCN Light Horse and jail staff. Now, this is the part that I wanted to point out. So we know all of that. If you followed any of the coverage of any of the other outlets when this happened, you saw that. This is what happened after that, and I think it's pertinent because it says shortly after the incident, the petitioner, that's Douglas, right, understands as the reason for his prosecution by the MCN, OCCJA Director Shannon Clark consulted with the Okmulgee County District Attorney. So what we're talking about here is Douglas, his boss, called the Okmulgee DA and he said, what am I supposed to do now? And the DA, who is an elected official, told him, take the guy into custody, take the person that the Light Horse brought into custody. And we're going to go on down here. Let me find the part. This guy has also been charged, right? So not only let me pop myself back up real quick. So not only did the Light Horse take this guy and there was a scuffle or whatever, but the guy who got into a scuffle with the Light Horse, that guy's boss called the Okmulgee DA, and the Okmulgee DA said, take the prisoner. So they took the prisoner and they charged the guy with the fentanyl. So he's been charged. So all of the stuff about people claiming that the Light Horse aren't the cops and all of that stuff is the opinion of a guy who works in the jail. The Okmulgee County DA said, take the prisoner and we're going to charge him. So he believes he has a case. He wouldn't have said that. He wouldn't have told him to take the prisoner if he didn't think that. Okay. So just to clear that up is that it was good enough for the Okmulgee County DA that it was Light Horse arresting this guy. Now, if we go on through Gettner's argument here, this is the part where let me bring that back up, talks about the status of Douglas as being detained and shows the legalese that they are using to say he's been detained when he is not actually being held, right? So it says detention is analogous to in custody. In the 10th Circuit, defendants who are released on their own recognizance, which Douglas was, he was released on his own recognizance by tribal courts, but remain obligated to appear for trial at the court's discretion, are quote-unquote detained. So that's the first part of it, is Gettner is saying he is being detained even though he's not physically being detained. Okay, let's go on down. And so the next thing that Gettner needs to address is what the felony that Douglas has been charged with, and can he be charged with it? So he's going to talk about, let me go back up a little bit. Sorry for jumping around. That Douglas doesn't have to exhaust his remedies in the tribal court because of that stipulation. And then also, let's go down here. This is still exhaustion of tribal remedies. I'm trying to find the section. Here we go. So this section, he starts to make his argument about whether Douglas can be charged with this felony assault of a tribal officer. And then he talks about the history here of Congress granting participating tribes additional limited jurisdiction over crimes committed by non-Indians, which Douglas is a non-Indian, and emphasizing that tribes are otherwise unable to exercise the jurisdiction granted under 1304. Congress defines special tribal criminal jurisdiction. Okay, so let's go on down. And it says, this is the part I was looking for. The MCN has charged petitioner with, quote, protected status battery, law enforcement et al., end quote, under 14 MCN 2-303B1. This charge appears to be based on the jurisdiction contemplated by 1304, which provides the term assault of tribal justice personnel means any violation of the criminal law of the Indian tribe that has jurisdiction over the Indian country where the violation occurs that involves the use, attempted use, or threatened use of physical force against an individual authorized to act for or on behalf of that Indian tribe or serving that Indian tribe during or because of the performance or duties of that individual in, and then it has these classifications. A, preventing, detecting, investigating, making arrests relating to, making apprehensions for, or prosecuting a, quote, covered crime. B, adjudicating, participating in the adjudication of, or supporting the adjudication of a covered crime. C, detaining, providing supervision for, or providing services for persons charged with a covered crime. Or D, incarcerating, supervising, providing treatment for, providing rehabilitation services for, or providing reentry services for persons convicted of a covered crime. So that's when, if tribal law enforcement are trying to do these A, B, C, D, if they're trying to do any of those things and somebody puts their hands on them, that person can be charged as long as the original thing is a covered crime. So we're going to go down here a little bit and see the statute further defines covered crime as including assault of tribal justice personnel as defined above and obstruction of justice. And keep going down. He talks about obstruction of justice here and explains from his opinion that to be a qualifying covered crime that allows a tribe to exert criminal jurisdiction over a non-Indian, then obstruction of justice requires 1, a violation of the tribe's criminal code, and 2, interfering with the administration or due process of the tribe's laws, including any tribal criminal proceeding or tribal investigation of crime. That the italicization of the tribe's laws is Gettner's doing, because he's going to make the argument that since Light Horse could not prosecute the guy who had the fentanyl because he wasn't an Indian, right? Then they can't charge Douglas with felony assault on a tribal officer because the Creek Nation wasn't going to bring charges against the guy with the fentanyl. If that makes any sense to you guys. I'm going to keep going down. I'm going to quote some more of this. Here's number 3. The events of December 18th did not involve the commission of a, quote, covered crime, end quote. Without reaching the merits of the MCN charges against petitioner, it is clear no covered crime as required by 25 U.S.C. 1304 was committed. Accordingly, MCN lacks jurisdiction over petitioner. That's not a very good explanation, in my opinion, just because he doesn't really say anything. He just says, obviously it's not. Let's keep going down. The arrestee was not charged with a covered crime. So the arrestee would be the gentleman who had the fentanyl, was arrested with the fentanyl. The arrestee, the MCN Light Horse sought to lodge in the jail, was accused of violating state narcotics laws, and the arrestee was subsequently formally charged in state court. Congress does not include narcotics charges or violations of any state laws as covered crimes 25 U.S.C. 1304. Accordingly, the MCN does not have jurisdiction to charge petitioner with a violation of tribal law for his conduct on December 18, 2023, as any alleged assault of tribal justice personnel must have been during or because of the performance or duties of that officer in detaining persons charged with a covered crime or incarcerating persons convicted of a covered crime. Now, I want to pop back in here real quick and remind you guys, I am reading Gettner's arguments, his filings for a writ of habeas corpus. This isn't my opinion. This is what he's going to argue in court to try to get this charge dropped off of Douglas. Douglas has got an arraignment on March 27th in tribal court on this, and then we'll see further, unless the federal court issues this writ. And then we'll go from there what's going to happen next, because I'm not so sure what would happen in that situation. Back to his filing, though, I think you guys can see what the argument he's going to make here is. He's going to say, hey, this guy you arrested, you weren't going to put him in tribal court. You couldn't put him in tribal court. In fact, he ended up in state court. So it's not a covered crime. Now, I don't know how far that's going to work. I think that if they could figure out something to charge the individual with, they might be able to obliterate that argument out of the water. I don't know. If you guys, by the way, I forgot to mention this, there's a link to this filing by Drummond in the description of this video if you want to read it more in depth and try to understand their argument there. I know, and I want to apologize because it could be it probably is a little confusing, the title of this video, because I don't know if you guys have heard, but Governor Stitt has sued the AG Drummond in court, in federal court, I think now. So that's also out there. I was referring to Drummond's filing against the Creek Nation. I might change the title of it later because it could be confusing. That I just read that story a little while ago, but that's also kind of funny. Anyway, I'm going to go on down here. Let's see, where are we at? 22 minutes. Do you guys have any questions? I want to remind you, you can pop them into the chat there and I will try to answer them. I'm not a lawyer. I'm just reading all this stuff. And let me jump down here a little bit further and see. There's one more thing I wanted to pull out here from his filing. Let's just read the conclusion, and then I'll give you guys an update on other cases that are in the federal court and other places. I know we normally cover stuff in the tribal court. Today it's mostly out of the tribal court. So I guess is that good? That's good. All right, let's take a look at this. Conclusion. Petitioner submits that his entitlement to a writ of habeas corpus is established as a matter of law without addressing the fact that he did not commit protected status battery, even if the MCN had jurisdiction over him. To be clear, petitioner believes that these charges are unfounded, unjust, and unwise, and he intends to vigorously contest them, either in federal court, if those facts were deemed relevant to this court, or in tribal court, if this petition were not granted. So there's our two options. Because, however, the MCN prosecution is patently ultra vires, the petitioner submits that this is unnecessary for the court to carefully examine the conduct that forms the basis of the MCN charges, and instead seeks an expedited ruling to end the respondent's clear abuse of the limited authority Congress has granted them to enforce MCN's criminal code against non-Indians. Therefore, pursuant to 25 U.S.C. 1303, petitioner Matthew Joseph Douglas submits this petition for a writ of habeas corpus and requests this court to grant the petition, dismiss the complaint, dissolve petitioner's release bond, issue injunctive relief against continued prosecution, and grant all other relief available under law and consistent with the grounds raised herein. Okay, so that's what they're asking for. Make the charge go away, make the bond go away, make it all go away, and really also give us a ruling here that they can't do it again. I think is also in here. Let me confirm that. Yes. Seeks an expedited ruling to end the respondent's clear abuse of the limited authority Congress has granted them to enforce MCN's criminal code against non-Indians. So they want They want a ruling set where the federal judge says, Creek Nation can't even do that. You guys can't do that. So that's what they're asking for. Will they get it? I don't know. I am going to be covering the Douglas's arraignment hearing in the court on the 27th if I don't get thrown out of court. Hopefully I don't. And we'll see what happens. What else? Okay, upcoming stuff. Ron Graham, you guys might remember from a previous Lawyered Up, we had Ron Graham on to talk about his lawsuit against the Department of the Interior and the Creek Nation in regards to the freedman status in the 1866 treaty. And that case right now, there was a recommendation that was filed in that case by a magistrate judge that he gave his opinion that the statute of limitations had run out on this claim that Mr. Graham had. So when that report and recommendation got filed, there's been a stay put on the case at the federal level until the final order comes out in regards to that. So they're waiting on a final order that's going to determine whether the lawsuit against Chief Hill and the Department of the Interior can be dismissed. And so they've said, hold on, we're not going to schedule any more hearings. Let's wait for this final order from the judge in the case to see if he's going to dismiss a case. And then if he doesn't dismiss it, we'll continue on scheduling and try to get to our trial date. So that's where that case is. They're waiting on a final order. Hasn't dropped yet. The Creek Nation's lawsuit against the city of Tulsa in regards to Hooper, that case, people are still filing things, so we're not anywhere near a decision on that case. What else? If you guys remember, we ran a story a few years ago about a teacher, Dallas Uten in Morris, who pled guilty to sexually assaulting a student and some other things. There's a civil case in that matter that's ongoing right now. And that case, they're having regular settlement meetings to see if they can achieve a settlement. But if they don't, in September, there is a trial date for the civil case of that. That's where the victims are going to try to get some monetary compensation back from Uten and the school district and other things. So I'm also keeping an eye on that just to give you guys a heads up. There hasn't been really any developments other than they're still trying to negotiate that and they're filing subpoenas for people to testify and so on and so forth. With that being said, I think that's it, guys. And we will definitely have another Lawyered Up probably the day after Douglas's arraignment, maybe even the day of, if I can get myself in there to see what happens, to let you guys know what's going on, because that's actually going to be in tribal court. And if you guys hear it, we're still waiting on the Strobel decision. The Oklahoma Supreme Court has not issued that. Next week, on Tuesday the 12th, we're going to have a live wire at 6 p.m. with Dr. Kirsten Kunkel, the Mvskoke opera singer and opera soprano and composer. She is doing another piece that's based on Creek Nation, and we're going to have her on to talk about that and what it means as far as the classical music world, etc. And today we had our Lawyered Up around noon, at noon. If you guys prefer having it over your lunchtime or during the day, let me know in the comments, or if you think we should go back to doing our evening streams, do them at 6, because I'm just trying out new things. So you guys let me know in the comments of this video if you want it in the evening so you can tune in better, or if it's easier for you to get here during the day, like at noon, and we'll make that adjustment. Thanks for tuning in, guys, again. I really appreciate it. And Mado Hadum Chihichathlis.